And now I'll give the floor to Mariano Genovesi of the Association of Pharmaceutical Companies of Argentina, CILFA, sorry. Thank you very much to all of you for your patience. Being the last speaker in the last session is not an easy task. I'll try and be very brief. IP on the regulations in the area of IP for the pharmaceutical industry is key. In the case of the Argentine pharmaceutical industry, as Carola was saying, the fact that for over 130 years pharmaceutical products could not be patented, well, this helped or this fostered the development of the domestic pharmaceutical company. And because of intelligent way in which the administration in Argentina implemented TRIPS, the joint resolutions and joint declaration, this helped to consolidate the development of the domestic pharmaceutical industry. Today, the domestic pharmaceutical industry represents 60% of market share in money terms and 66% in units for 2 or 3 days. Now the first monoclonal antibody, the biosimilar monoclonal antibody, has been traded. And this is a result of a state policy which has been in place for several decades, whereby private authorities and the private sector developed an industrial development, economic development policy which allowed or which enabled the health authorities to have a tool to deploy their policies. Today, the pharmaceutical industry in Argentina creates 30,000 direct jobs, 100 indirect jobs,
a más de 80 países de la región. Hay empresas
and exports to many countries in the world. We have some countries. Our experts are working in companies in Argentina and in other continents too. I'm very proud of this because this industry has grown thanks to the private sector drive and thanks to the encouragement and the drive of the public sector. So intellectual property regime is key because, well, we have been talking about flexibility, which is the execution of the obligations and the rights that we have as a result of multilateral agreements. We won't have a local industry. But this is not enough. There are other necessary conditions, which I'm not going to expand on. But, of course, the intellectual property framework is key. And the state policy regarding intellectual property in Argentina has been very important, and it has reached its summit with a guidance for the patenting of biotechnology and pharmaceutical mentions, which was passed 2 years ago. This is a joint declaration. And Thomas explained earlier on, as well as Carola. Carola also mentioned this, and this has had an important impact for the pharmaceutical sector. The fact that a product may be launched means that you have to investigate what is happening with the patents. In the case of ritonavir, we know there are 105 families of patents for these agents, and there are 9,000 patent requests all over the world. So you need a lot of money to invest and to analyze this. So many people feel discouraged from launching a product.
So if there are guidelines where this is very clear and we give clear instructions of what can be given a patent and what not, without introducing new criteria, but just applying the standards that are accepted by the Argentine law for the pharmaceutical field, this provides certainty. And in 2 years, we can show the success of this policy. Argentina has granted 200 patents per year. That was like that, but today it is only 50. There is a stock of applications pending resolution that was really important, and in 2 years, 2,865 were abandoned because INPI requested the applicants to state the new criteria, and they simply did not insist. And of all the patents that were denied, only 6 went to the courts. So we see that this rationalization was a success, and many of the applicants did not consider the patent was good enough to go to the courts. So if we reduce the applications to just the number of products that really have a use, it is very important to ensure competitiveness in pharmaceutical markets. Now let me go and detail the FTAs. Unfortunately, the multilateralism is dead. The WTO is an empty organism, and it's not the WIPO or the WTO or the WHO. It is the regional and bilateral treaties where we discuss issues and concerns. It's already been explained how certain standards try to be forced upon into to countries. But the FTAs, those that are already being negotiated, do not standardize right so much that forbid certain discussions as to define what is an innovative novelty, what is innovation, what is sufficient dissemination. Though there were some attempts, late 90s, early this century, certain things that were negotiated in the WIPO, but probably in the next 10, 20 years, these issues will be discussed. Meanwhile, we have room to regulate things domestically. I agree with Carola. In order to move forward, in Argentina, directions are very clear, but the minister should make the resolution. So these FTAs, regional FTAs, really can anchor ideas and standards. Even though Argentina has moved forward, Uruguay has also produced some progress, but in a different way. Uruguay has just reviewed literature in terms of salts, isomerase, Marcus, etc. But patents are reviewed case by case. That is what happens in Mercosur in current days. So we need to discuss, and these international treaties are important. When in Colombia the superintendents issues its own guidelines before signing an agreement with the U.S., there were some things in the standards that were against the 426, and it was the 426 and this idea of industrial application or the prohibition to patent therapeutic methods that led to a denounce that certain guidelines were not complying with the 246 article, because when you have international commitments, you have to comply with those, and some come from human rights regional or international agreements that somehow show the way to health officers. So I believe certain things should be discussed in pharmaceutical fields. Regionally, we have to discuss whether Argentina guidelines can be expanded to other countries. Brazil has done something, Paraguay has done something. They have implemented useful tools to preserve a public domain and avoid irrational competition in the market. As to the change in the paradigm, multilateralism has been abandoned, but it seems that trade-off between market access and intellectual property has reached a limit. Peru, Chile have nothing to obtain by trading off and giving more protection to intellectual rights. We have to implement patentability criteria that go against what some countries in the region are fostering. And this is something that is not very noticeable to lawmakers, to health officers. How can we train an examiner? When somebody comes from the European Office of Patents, they say these are our criteria, and probably those criteria are not the most convenient to these countries. So regional technical assistant cooperation are crucial tools if we want to pay attention to what we are doing. We need technical cooperation. We need to train our technical advisors in terms of intellectual property. You said that the competition was not very loyal because examiners are hired by the private sector. I remember 8 years ago when the INPI was left without examiners, and together with the University of Buenos Aires, we had to improvise and train examiners very quickly to fill in the gap. So we need technical assistance, we need international cooperation from WIPO, bilateral agreements, because they are very important to implement criteria not only to foster public health, but to avoid those that foster private interest. Prosur should get together, exchange experiences, develop software, develop guidelines, criteria. This is not good, it is not bad, it seems to be good. The idea is how we use Prosur. Do we use it to go deeper into health policies to protect the public domain, or to foster patentability criteria that go against the interest of the countries in the region? So I think we should preserve negotiation positions, what Carola just mentioned, the negotiation between the European Community and Mercosur, and the region has been very clear about which are the lines we should not cross in terms of compensation, exclusivity, etc. And the Pacific, the Trans-Pacific countries that are negotiating their FTAs, we should pay attention to the small the words of the small print. When we regulate the criteria to present evidence, we have to understand this new chemical entity issues, and I can give you thousands of examples. The last version of the TPP as to requirements do not say what a novelty is, because I said I want to apply the concept of innovative concept, because this is more stringent than other requirements. So, in short, this is a battle we should fight every day. We've been in a favorable international context or in a less favorable context to strengthen intellectual property, not as strong as it was in the 90s, but the pendulum goes and comes back. We need things to last a long time. We need regional agreements to anchor these policies so that these policies last and can derive or lead to industrial policies, to pricing policies that will provide certainty and access to everyone. Thank you very much. Thank you for allowing me to be here, to meet colleagues, friends, people I haven't seen in a long time, and share these ideas and receive yours. Thank you very much.